Whenever you're ready, counsel.
Morning, Your Honor. Michael Herlick on behalf of Mr. Duncan. I represent the appellant. If I could just reserve 3 minutes, for rebuttal.
All right.
Your Honor, this is a case involving question about whether or not law enforcement officers had probable cause to arrest Mr. Duncan. This case arises out of a sting operation that was designed to apprehend individuals soliciting minors for sexual conduct over the internet. The way that works is there's essentially 2 parts to the arrangement. There's a section of chatters and their supervisor that contacts individuals over the internet, makes contact, tries to get them to agree to involve themselves in sexual conduct and to travel for that purpose. And then they are directed to go to another location where the second part of the operation is set up with an arrest team and a surveillance team. And it's there where the people are directed to and where the arrests actually occur. The way this process is designed to work is that as the chatters are establishing relationships and establishing communications with these individuals, they communicate with their supervisors. Their supervisor then communicates to the arrest team and the surveillance team on what to expect. But as you might imagine, there are a lot of these individuals going on at one point in time, and they don't have a determined timeline for when these individuals are going to appear or arrive.
Now, there's no issue as to whether Mr. Duncan actually appeared at the decoy home. I mean, he was there, correct, in his Silverado truck?
He was arrested there, and the issue is whether or not his arrest was lawful. Okay. And essentially what it ended up happening.
He arrived there within a couple of minutes of when he texted saying that he's in his truck and he's right outside, or he'll be there in a couple of minutes, or words to that effect.
What happened was the text message, or I think we were using some sort of app, a message was sent over that program. At some point in time, there was a message sent, "I'm here in a truck." At that point in time, there was no one fitting the description in front of the home. It was only until later, when a truck arrived at the same time as a sedan arrived, that they made the decision to make an arrest of both individuals. And that is really the key issue in the case, is that multiple individuals are in front of the house, and that the officers who made the arrest.
Were there any other trucks out there?
No, it was the sedan and a truck.
Nobody saw another truck go by there at any time relevant to the discovery of the case. Is that right?
Right.
There were no other trucks came by, stopped, turned around, paused, or were otherwise visible in the neighborhood.
That's correct. But essentially, under that theory, then there would be probable cause for any truck that drove down the street.
Well, not any truck. I mean, under the fellow officer rule, they were entitled to accumulate their knowledge as to what led up to this, the officers, correct?
And the knowledge they accumulated was, as we've cited in the cases that we've cited in the motion, was essentially bare bones. It was a description of a white male arriving in a truck. And that was essentially all the information they had at the time that they made the arrest. And that, under those 2 cases.
Well, they had the countdown as well, right? Where he was 30 minutes out, then he's 10 minutes out, then he's 5 minutes out. He was sort of counting it down with his text messages.
And then when he supposedly texts, "I'm here," he's not there. And so there was no information as to what truck was coming. There was no description of the truck. There was no color, make, model, anything along those lines. And it's also unclear as to what was really communicated to the officers that were on scene, that were effectuating the arrest, in terms of whether or not they could establish corroboration with the truck that appeared, with any of the factors that they had learned. And so essentially they are arresting a person that arrives in a truck, no matter what truck that is, no matter what that truck does, based upon that understanding of the law, which is not what London and Bellamy say. What London and Bellamy
Mr. Herliga, let me ask you a different question. The state says that they could have tried this case even if the evidence had been suppressed, which would mean that this is not a dispositive ruling. Can you please address that?
I think that was addressed at the trial court when the trial court asked that question to the state in terms of what issues would be left for the state to be able to prove, and that would be the identity issue there. And the trial court directly addressed that with the state and gave them the opportunity to present on the record.
Well, the state didn't stipulate that it was dispositive, but they didn't at that time say one way or the other if they thought they would be able to try the case without the evidence of the arrest.
I believe their response was that identity was obviously the issue and that the judge had all the information to make the determination of whether it was dispositive. They submitted no other additional information at that point in time. They did not say they had additional witnesses that were not presented at the motion to suppress or additional evidence that was not presented at the motion to suppress. And so they had their opportunity at that point in time to make an issue of whether or not it was really dispositive. And they elected essentially to remain silent on the issue. They weren't stipulating, they weren't particularly actually making any sort of argument as to whether it was dispositive either. I think that clearly shows there wasn't any evidence, and the record reflects that as well.
I'm not sure that really answers Judge LeBrit's question. We're going to make our own independent evaluation of whether it's dispositive. So could you speak to that without just reciting what transpired? Why should we conclude that it was dispositive?
If the motion to suppress were successful, then his arrest at the home would have been suppressed. There would have been no information whatsoever that he ever traveled to meet a minor. There obviously was text messages, there obviously was photographs that were sent, but there has been no actual verification that the person that was communicating was Mr. Duncan, that the photograph was sent by Mr. Duncan himself, or that he ever actually traveled there to meet anyone, because his arrest would have been suppressed. He never would have been there on scene and found to have been outside the home. And so there would have been no evidence to establish the elements of traveling to meet a minor, so it would be dispositive. And going back to the issue of probable cause, ultimately what they have is an issue with the information they had at the time. They had white male, they had truck. At the time that the arrest was made, there was another white male there in a sedan, and essentially the decision to arrest them occurred as the individual got out of the sedan, walked up to the truck, started to engage the person in the truck in conversation, and that's when they decided to arrest both individuals at that point in time as a sort of operational security issue. At that point in time, they had not verified that the photograph that they had was a driver of the vehicle in the truck. They had not verified the color of the truck was the driver's color of the truck or any sort of make or model. And it was certainly an arrest. It was not just this detention under reasonable suspicion under a Terry stop. They opened the door, pulled Mr. Duncan out, and effectuated arrest there, put him in handcuffs, and he was transported to a different location. In order to do so, they had to have probable cause. It's our argument at that point in time, they did not have probable cause. And looking at the application of the facts of London to this case, it's clear that bare bones bolo that they had was not enough to support a probable cause arrest. In London, they had a race, sex of a driver, and a vehicle. That's the information they had here at hand. The officer in that case made a decision to stop the vehicle and effectuated arrest, and that was determined to be illegal. In Bellamy, they had same thing. It's sort of a description of a race, sex of a male. They had a generalized description of his clothing, and even in Bellamy, saw suspicious conduct of what appeared to be a potential hand-to-hand transaction. That was not enough to suggest probable cause to effectuate an arrest. We're arguing that this case is on, all fours with those cases in the sense that this is a bare bones bolo. There was not enough probable cause to arrest Mr. Duncan, and because of that, his arrest was illegal and should have been suppressed. If there are no other questions, I just yield the rest of my time.
Okay, thank you. Ms. Jensen?
Good morning. May it please the court, counsel Kirsten Jensen on behalf of the state of Florida. In this case, the police officers did have probable cause to arrest the appellant. Under the fellow officer rule, it allows the arresting officer to assume probable cause when directed by another officer to make an arrest. And the arresting officer does not have to have sufficient firsthand knowledge of the reasons behind the probable cause. In this case, It's a multi-officer effort and a child sexting operation. Officer Kirby is the chatter. He is the officer that developed probable cause. He posted a profile on an app called Me24. Appellant responded to that. At appellant's initiation, he sent sexually graphic messages in indicating his intent that he wanted to have illegal sexual contact with a presumed 14-year-old. And what the difference is between this case and the Bolo cases is that this is a crime that is happening in real time in front of the officers. So as Judge Black pointed out, you have the countdown, I'm almost here. You have then the message, I'm here, my truck. You have Officer Goodlet, who is the officer that's posted outside of the house, who testifies that within a few minutes of this text, I'm here, my truck, he sees a truck pull into the neighborhood, turn around in the driveway, and park in front of the decoy house. There were no other trucks that entered into the neighborhood during that time. And based on a objectively reasonable officer, probable cause existed to believe that the person that was sitting inside that truck was the person that was communicating his desires to have sexual contact with a 14-year-old to Officer Kirby.
So, Ms. Jensen, could you speak to your opponent's position about the dispositive nature of the ruling and what you argue in the brief that the state could have proceeded to prove the elements of the crime through various other evidence? Your opponent argues, of course, that without the arrest, this goes nowhere. Please address that.
Based on the record that's before the court, I think it's a reasonable argument that the appellant's motion is not dispositive. The unchallenged evidence includes photographs of the appellant, the messages from appellant, and also his admission that he is parked in front of the decoy house in his truck. People do not have a privacy interest in the outside of their vehicles. So testimony could be provided that a truck did pull in front of the house at the same time that the appellant was texting Officer Kirby that he was there in front of the truck.
The appellant, was he the registered owner of the truck?
The record does not reveal that.
And that, but you argue that you could have relied on that evidence.
Well, I think I did say that it is a possibility that the state could verify that the truck is registered to him, but based on the record that is before the court, it is not clear, other than what's in the record, what evidence the state had to proceed. However, just based on the messages, the photographs of the appellant, that a truck was parked in front of the house, I think circumstantial evidence that appellant was the person that was that did arrive in the truck. The state does have a circumstantial evidence case that he was the one that was committing the crime. But it really doesn't matter, because even if you do get to the merits, probable cause existed to arrest the appellant. If there are no further questions, then the state will rely on its brief and ask that this court affirm the judgment and sentence.
Hey, thank you.
Thank you.
Buttle?
Yes, just briefly. I think the issue as far as the dispositive nature is, the state says that it's the appellant's text, but that really could only have been proved by the fact that he was arrested at that point in time circumstantially. There's nothing in the record to suggest that can be linked to the appellant or Mr. Duncan in any way other than the fact that he was arrested there. There's no testimony from any officers that can identify him at that point in time. There's no testimony about the record of the car being.
So are you saying that
registered.
the officers couldn't have testified based on the photograph in his profile to identify him?
At the hearing, there was that question was asked whether or not they could identify the individual in the truck at that point in time, and they essentially responded that they could not. What they did was they went to arrest him, and if you're suppressing his arrest, then they, at the time when they actually were able to observe him and make that observation, he was in custody, and that would be suppressed. And so
that's not really my question. My question is that there's a photograph on his profile, and your position is that the officers couldn't later identify him based on that photograph?
The
I'm not talking about
yes,
what
the
they
officers, the officers would not be able to testify as to that this photograph that we received is Mr. Duncan, because at that point in time, they'd essentially be placing themselves in the position of the jury and taking the jury's question of whether or not that really is Mr. Duncan. They're in no better position to answer that question than the jury would be. They could say, well, the person that was outside the vehicle was Mr. Duncan, and I see him in the courtroom. But that was, like I said, that what the testimony at the hearing is that by the time they were able to make that observation, he was arrested, and that would be suppressed. And so we'd ask is that this be remanded and that the trial court's verdict be overturned as far as the motion to suppress is handled. And that concludes my argument.